We're recording.
Good afternoon, everyone. Welcome to the Appellate Court. I'm Judge Bright. I'm sitting this afternoon with Judge Moll and Judge Baer on the matter of MENARD versus State of Connecticut. Docket number is AC 42342. The oral argument is being conducted over the Teams platform, so everyone is appearing via video conference. The argument is also being streamed live on our YouTube channel. I'm going to ask everybody to introduce themselves so that we can make sure we can all hear and see each other okay. I'll start with the judges, then counsel for the appellant, then counsel for the appellee. Again, I'm Judge Bright.
I'm Judge Moll.
Judge Baer.
Good afternoon, Your Honors. I'm Daniel Krish. I'm counsel for the plaintiff's appellants.
Good afternoon, Your Honors. Attorney Dave Haught, Cooney, Scully, and Dowling, and I represent the state of Connecticut as an appellee. And cross.
I can hear. Yes, as a cross belly, we'll get to in a minute. I can hear and see everyone okay. Attorney Krish, you were a little quiet. I don't know if you might want to move closer to your microphone. I've never had a problem hearing you in the past, so I'm sure you'll speak up. I'm going to ask everyone during this conference to do a couple things, or during this argument to do a couple things. Number one, although we are not in the courtroom, I would ask that everyone behave like they're in the courtroom. I don't expect that will be an issue with the counsel we have here today, but we've had some surprising and a little bit disturbing experiences recently with behavior during argument, and we would just ask that you conduct the argument as if you were standing at 75 Elm Street in our courtroom. Second, I'm going to ask everyone to keep their microphones muted during the argument when you're not talking, so we can avoid any background noises and avoid talking over each other. If you're unable to see anyone during the argument, please let us know that. If you're unable to hear anybody, please let us know that. And if you get disconnected from the conference for whatever reason, please log on, click on the link to log back in as soon as you can. We will suspend the argument until we know that we have everybody present. And while we would ask that your microphones be muted, we would ask that you keep your cameras on at all times so we can make sure everybody is present and appropriately engaged in the argument. The judges will raise our hands if we have questions. We'd ask that counsel recognize us when we do that. If you don't, we'll just jump in like we would in the courtroom. But again, we're trying to avoid talking over each other. Each side will have 20 minutes to argue. Both the appellant and the cross appellant can reserve time for rebuttal, so the order will be a little bit different than when there is no cross appeal. The appellant will go first, the appellee, the appellant's reply, and then the cross appellant's reply. So you'll just need to let us know how much time you want to save of your 20 minutes for rebuttal. I will keep the time, although we don't have our light system available. I do have signs to hold up. So at 2 minutes, at 1 minute, and when your time is up, courtesy of Judge Moll. So with that, I think we're ready to proceed. Attorney Krish, are you ready to go?
Yes, thank you, Your Honor. May I please reserve 4 minutes for rebuttal?
Sure.
Thank you. May it please the court, I'm Daniel Krish for the plaintiff's appellants. This appeal primarily concerns 2 improper limitations on uninsured motorist compensation for police officers who suffer PTSD in the line of duty. First, that PTSD as a result of a physical trauma and with physical manifestations is not a bodily injury under the UM statute. And second, the state can deduct workers' compensation benefits from an award without the same notice to an insured that a commercial insurer would have to provide. Both of these limitations are inconsistent with the remedial nature and purpose of the UM statute. I want to start with the PTSD issues. That's the biggest issue. I think the text and purpose of 38A336 and the cases that interpret it, both in Connecticut and out of state, make it clear that PTSD caused by a physical trauma with physical manifestations constitutes damages because of bodily injury. It's important to recognize, of course, it's a remedial statute. So the trial court is only right in reaching the contrary conclusion to that if the statute is unambiguous that it precludes damages for PTSD. First, statute doesn't define bodily injury. That doesn't always mean a statute's ambiguous, but it certainly can be a hallmark of ambiguity. And we cite several cases in our brief, and particularly the Raftapol case from the Supreme Court, but the lack of a definition certainly not helping make a phrase clear. And there are three, yes, Judge Bright.
I do not read Judge Shapiro's decision as finding the statute to be unambiguous. He looks to extraneous sources to interpret the phrase bodily injury. So do you believe the court found it to be unambiguous, or do you believe the court agreed with you that it's ambiguous?
I think it's possible to read his decision either way, because he starts his discussion of the statute with a sentence that makes it sound like this bodily injury is clear and unambiguous, but I do agree with you that he also looked at extra-textual sources. So I don't think the court has to fight that battle if the court believes that he found it to be ambiguous. Certainly, we think we have the better reading. And of course, because it is a remedial statute, if there are two reasonable interpretations of it, this court should, if possible, reach the one that favors and furthers the purpose of the statute. That is to ensure that motorists who are injured recover as if they would if the tortfeasor had adequate insurance.
So if I could ask you a couple other questions just to help frame the issues in my mind. You said that there has to be PTSD accompanied by physical trauma. So if there was a situation, say this accident happened and the car flew over the trooper's head close by, but did not hit them, and they claimed that they suffered post-traumatic stress disorder from this near-death experience, would that be compensable under the statute?
Yes, if there were physical manifestations of their PTSD.
Okay, so that gets to my second question. I'll let you explain. I didn't mean to cut you off, but you said if there's physical manifestation, or if the physical trauma was caused by, or if the PTSD was caused by physical trauma. So is it your view that either one of those satisfies the statute, that you can have PTSD that is accompanied by trauma or caused by, but it doesn't have to be caused by the physical trauma?
I think the answer is yes. I'm hesitating only because I'm not sure what you mean by caused by the physical trauma. In a medical sense, of course, PTSD is not caused by physical trauma. It's caused by a mental process, and a triggering event, a life-threatening event, causes your brain to re-experience it when you are triggered. So you don't have to have some physical event cause the PTSD. I am using physical trauma in the way I think a lot of the cases use it. That is a physical event that threatens your life. In this case, you use an example that is actually very close to what happened to Trooper MENARD, that the wheel of Trooper Zadrowski's car came within a foot of crushing his skull. Now, in this case, both of my clients also suffered physical injuries in the accident, simultaneous with their emotional trauma and belief and fear of imminent death. But I don't think physical injuries are required. What's required is physical trauma, a physical event causing a traumatic experience, and or physical manifestations like from MENARD's severe headaches caused by his PTSD. And that was diagnosed by Dr. Silverman, his neurologist, that the PTSD was the cause of his headaches, not the head injuries that he also suffered. I think if you look at the plain language of the statute, it's broad. And the most important phrase, I think, is obviously because of bodily injury. And bodily injury, if you look at the meanings of those words, injury is hurt, damage, or loss. Bodily means relating to or concerning the body. If you tie those two phrases together, damages because of hurt, damage, or loss, bearing on, pertaining to, standing in some relation to, those are the definitions of relating to and concerning, in association or connection with the body. And yes, Judge Barrett. Judge Barrett, you're muted. Sorry.
I understand why we're talking about this very interesting issue in this appeal, but do we actually have to get there in light of what Judge Shapiro found concerning the testimony of Jennifer Honan? He found that she acknowledged she did no screening to assess the validity of their statements concerning their claims of emotional distress. Rather, she accepted their statements without making an independent assessment. The court does not credit her testimony or her diagnosis. And the first part of that sentence or that paragraph is where the court discusses that she determined that each of the plaintiffs met the criteria for having PTSD. So in light of, how do you, if you will, get around that to get to where you are in your argument?
Yes, Judge Barrett. So that's clearly erroneous. His disbelief of Honan is clearly erroneous. There is a rule discussed at length in our brief that you cannot, as fact finder, arbitrarily disregard an expert's testimony. Right? And what arbitrary means, I think the First Circuit case that we cite, the Quintana Ruiz case, says where you have unequivocal, uncontradicted, and unimpeached expert testimony about a topic beyond a lay person, which Judge Shapiro in this context is, you can't just disbelieve it. Now, what do we have in this case? No expert for the defense to counter Ms. Honan's opinion. Ms. Honan was not confronted with some learned authority or treatise that impeached her credibility as to her method of diagnosing my clients with PTSD. The trial court added on its own factor that it felt she should have used, that it should have somehow screened out mendacity by asking questions to determine if they were lying, when that is not something that the DSM 4 or 5 requires. That's not something that is one of the diagnostic tools. It would be as if an expert in a medical malpractice case said, this is how you diagnose a heart arrhythmia. You look for factors A, B, and C. The trial judge says, well, did you look for factors D, E, and F? She says, no, that's not what you do. And then refuses to believe the expert because she didn't look for factors D, E, and F. That's simply not how you diagnose post-traumatic stress disorder. And in light of that, Judge Shapiro's decision, although it is a factual finding, is clearly erroneous. Just like in some of the cases we cite, I would point especially to the Bodie case that this court decided a few years ago, where the issue was, it was a workers' comp appeal. The issue was the workers' comp commissioner and the board affirmed the finding that the gentleman was employable. And there were a set of vocational reports. The earliest vocational reports that he was, all the later vocational reports that he wasn't. And the workers' comp commissioner just decided, I'm just going to believe the first one and disbelieve the later one. And this court said, listen, yes, that's a factual finding. Yes, we usually defer, but that's just arbitrary. You had no good reason to discount all these later reports and to believe this first report. In this case, Ms. Honan testified to the methodology for diagnosing PTSD, that she didn't just take their word, that she looked for physiological signs that they were in fact suffering from PTSD, that they met the criteria, and that she treated them. And she was specifically asked, after Judge Shapiro asked this question on redirect, that did she see any evidence that they weren't telling the truth? And she had no indication of that, no doubt of their sincerity or honesty. And the record supports that too. Mr. MENARD treated 100 times with Ms. Honan between 2013 and 2017. The idea that he was making it up for 100 sessions with her just doesn't accord with reality. Yes, Judge Blake.
So when Judge Shapiro asked that question about whether she checked if they were dissembling or lying, didn't that reflect that he had questions about the credibility of the two plaintiffs and whether they were being truthful about what they were experiencing?
He may have. He didn't question either of them when they testified.
No, but he doesn't need to. I mean, as a fact finder, couldn't he just listen to them and say, I don't believe them? We've had other cases. I've had him as a trial judge, as an appellate judge, where a jury has heard someone has gone to see a chiropractor 100 times and said, I don't believe it was medically necessary and has denied economic or non-economic benefits. Why can't we read Judge Shapiro's decision as kind of saying, I don't credit her testimony because I don't credit their testimony, and if she relied on it, I don't find it to be reliable?
Well, first, he didn't say that in his decision, Judge Bright. His decision's not ambiguous. He has one paragraph where he says he didn't believe her because she didn't do any screening to test the validity of their claims. He did not say in there, I don't believe these gentlemen. He discussed their testimony, other parts of the decision, didn't say that he found them not to be credible. And in fact, in other parts of his decision, it's reasonable to infer that he found them to be credible because he rejected the state's argument that Trooper Jodorowsky was contributorily negligent in how he parked his car and was partially a cause for the accident. He found for the plaintiffs, rejected that argument, and simply disbelieved Ms. Honan for a reason that is in no way a part of the methodology to determine whether somebody has PTSD or not, without any basis in the record to do it. No expert for the state, no learned treatise or authority that impeached her on that point. And you know, the reason that he talks about, and this is in his discussion of the statute, but it, you know, read his decision as a whole, he talks about, you know, police officers, they re-experience these sorts of traumatic events all the time in their jobs. I think it reflects the reality that the people, his requirement would disqualify many of the people most likely because of their jobs to get PTSD. You know, if there had been expert testimony on the other side, so and I'm going to mispronounce the name, but the Wismarowski case from the Supreme Court, case about a doctor who diagnosed somebody and said, I base it on this fact not being present, when in fact the fact was present. And the trial judge disbelieved them, and this court, the Supreme Court rather, rejected a challenge identical to the challenge we're making, saying, well, there was a basis for the trial judge in the record to disbelieve this expert, even though he's the expert. Here, there's just nothing in the record. I do want to quickly talk about the workers' compensation issue. This is all about how this court interprets the holding in PIRSA about what a self-insurer needs to do to have rough equivalence with what a commercial insurer would have to do to allow the insureds to be aware of the fact that workers' compensation benefits will be deducted from any award. It's important to remember the regulation is permissive, right? Insurers don't have to do that. They can, but they have to give notice, right? If you're a commercial insurer, you do it by putting it in the policy. Self-insurers don't have a policy. PIRSA says there's other ways they can comply, but in PIRSA, the city of Hartford had done nothing. So the ideas that PIRSA discusses are dicta. Here, all the state did was prepare a memo and put it in the Insurance Risk Management Board's file. It's stipulated they didn't give notice to the state police officers union, to the representatives, or to these particular plaintiffs. And I just asked the court to consider if this were commercial insurer who was trying to claim that that was sufficient, right? We didn't put it in the policy, but if you came to our offices, there's something in the file that would tell you that this was the case, whether that would constitute sufficient notice. Unless the court has other questions, I will reserve the remainder of my time for rebuttal. Thank
Okay,
you.
4 minutes for rebuttal. Attorney Hall, how much time would you like to reserve for rebuttal on the cross appeal?
I think I'll just reserve 3 minutes, Your Honor, if I could.
Okay.
May it please the court. I think that there's 3 points here I'd like to touch on briefly. I think the first one relates exactly to the question that Judge Baer raised, and that is, why are we even reaching this question about PTSD? Because the trial judge in this case, Judge Shapiro, found that Jennifer Honen's testimony was not credible. He did not credit her testimony. I happen to have had the advantage of being the trial lawyer in this case as well. And she was not a credible witness. She made no effort to determine if her clients were telling her the truth or were relating the acts as the facts that they were relating about the accident, whether they were factually correct. She took no history from these individuals. She performed no testing, which is standard in these cases, to screen for malingering, particularly where we have 3 seasoned police officers who all claim the same diagnosis, who all end up in the same Jennifer Honen's office. She simply established no foundation for her opinions. Judge Shapiro, as the trier of fact, is entitled to make a decision whether to credit her testimony or not credit her testimony. That is black letter law. He chose not to credit her testimony. The standard here would be whether Judge Shapiro was clearly erroneous in doing so. And I don't see how this court gets to the secondary, whether PTSD is recoverable. I don't see how they even get to that question based on Judge Shapiro's finding. Point number 2 is whether PTSD type damages are recoverable in a case. I'll stand on my brief. I will just reiterate that the statute that we're dealing with here, the statute, specifically refers to bodily injury. I don't think it's ambiguous. I don't think Judge Shapiro found it ambiguous. And the Judge Shapiro also found, as a matter of fact, that the plaintiff's PTSD claims in this case were not a result of personal injuries. So,
Attorney Hall,
yeah, yes,
I could just
right.
on this question of whether bodily injury, that language is clear and unambiguous. In the cases that you rely upon, and that Judge Shapiro relied upon, that discuss bodily injury in insurance policies, didn't the 2 primary cases conclude that the phrase bodily injury was ambiguous and look to extra-textual sources to determine what the meaning of bodily injury was?
Clearly, they did that.
So why wouldn't that be true here?
Well, I think in the I don't agree that it's. I mean, I don't agree that it's ambiguous. Okay.
Our Supreme Court has said that is ambiguous in a related context, and you want to argue, and Judge Shapiro found that that related context applies here as well. So, I mean,
I think the issue here was it was not related to a personal injury, and I think that sort of takes some of the ambiguity out of this case, because that's not the situation that we have here. This was it was clearly unrelated. Judge Shapiro found, as a matter of fact, that it was unrelated to their personal injuries, and I think that's what made the issue easy. That's my position on that. And the case law says,
your position is that he found that it wasn't a damage because of the bodily injury.
He said that in his decision, Your Honor.
Right.
Right.
Okay.
And the case law says that emotional injuries, not caused, the cases that I cited, purely emotional injuries not caused by a physical injury are not recoverable. I'm going to skip the issue related to workers' compensation because I think the brief covers it. I think that's easy. But I am most interested in the third point that I'd like to address, and that is what I'll call the Del Greco decision, which is on our cross appeal. And I want the court to understand up front that I am not asking them to overturn Del Greco or hold that the Supreme Court has somehow misinterpreted or made a bad decision in the Del Greco case. What I want the court to understand is that we have a different factual scenario in this case. In Del Greco, you had a situation where there was never going to be enough money to compensate the injured party. It was never a double recovery situation. In our case, we have all of the various recoveries that these three plaintiffs received, and we have $1 million of underinsured motorist coverage, and the claims never reached those limits. So what we have here is a situation where if Del Greco is applied as a sort of a broadly that a dram shop recovery can never be a set-off in a case under any circumstances, then what we are doing here is allowing a double recovery for all of these three plaintiffs. Yes, Judge Bright.
So, well, when you say these three plaintiffs, one is out of the case.
One's
right?
out of the case, two plaintiffs.
And as to MENARD, if
Correct.
we agree with you on the issues raised by the appellant, and if we affirm Judge Shapiro on that, we don't need to reach this issue as to MENARD because Judge Shapiro's already zeroed him out, right?
That is correct, Your Honor.
Okay.
That is correct.
So it's really just as to Connolly. That
correct.
If we agree with you, and I'm not saying that we do, but if we were to agree with you.
This is true. MENARD is already in a negative position by about $10,000 or $12,000. Connolly is in a positive position. But I don't think there's any question here, and I don't think the plaintiff disputes that, let's say, as to Connolly, if he is allowed to keep this dram recovery, it is a double recovery. He's receiving far more than what the court has deemed to be the fair value of his injuries. And that is contrary to tort law in general, law for sure. I did not reference in the brief, but I do, being an attorney who litigates these cases, I do rely fairly heavily on the Connecticut law of uninsured and underinsured motorist coverage written by Burke and Jane Schill. This is a book we all use, a secondary source. And in section 4.9D, and it's cited in one of my post-trial briefs, but I don't think it made it into the appellate briefs, they have raised this very point where Del Greco is a question, how to apply Del Greco is a question mark in a case where it would permit double recovery. And they certainly have concluded in their treatise on law that that the Del Greco decision should not apply when you have a situation that would otherwise permit a double recovery. So I think that Del Greco is easily distinguished in this case, and this is not a question of overturning long existing precedent by the Supreme Court. Thank you.
Okay, so you'll have, to the extent you want to use it, about 11 minutes left for your rebuttal. Attorney Chris, you have 4 minutes left for your rebuttal.
Thank you. First, it's not standard in PTSD cases to grill your patients about the underlying facts of the stressor event that gave them PTSD. In fact, Ms. Honan testified, and the DSM-4 and DSM-5 both say that's a bad idea because it causes them to re-experience the trauma. It is true that my brother counsel did cross-examine Ms. Honan quite a bit about her failure to screen the validity of their claims. But the DSM supports her position. In the DSM-4, which is the operative DSM at the time, right, It says, malingering should be ruled out in those situations in which financial remuneration, benefit eligibility, and forensic determinations play a role. And then malingering, which is a differential diagnosis in the DSM-IV, is defined as intentional production of false or grossly exaggerated symptoms, strongly suspected because of the medical legal context, that is, referral by an attorney to a treater. Right? Mr. MENARD and Mr. Connolly both started seeing Ms. Honan long before they filed a lawsuit, a year before they filed a lawsuit. They were not referred there by an attorney, and malingering is not, yes, just right.
So was DSM, was what you just read an exhibit during the trial?
No, it was not, but it was referred to in Ms. Honan's testimony as the authoritative treatise. And
but did she, that language you just read us, was that language introduced before Judge Shapiro?
No, but the DSM is a reference work that both this court and the Supreme Court referred to without it having been an exhibit at trial. In the Squayo case, the Supreme Court did that with respect to the DSM. And this... But
I guess you have 2 minutes left. I guess the question I have on the DSM is, can we consider whether the trial court's credibility finding was clearly erroneous based on information that we have that the trial court didn't have?
Yes, because clearly erroneous doesn't depend on facts before the trial court. It depends on facts in the record. And Ms. Honan, first of all, Ms. Honan testified to the substance of what I am telling you without quoting the DSM. She didn't quote it from memory, but she referenced the DSM, said she diagnosed them pursuant to the DSM. And Judge Shapiro, again, chose to discredit her for reasons that he just introduced into an expert testimony without there being any basis for it. And the DSM is an authoritative reference work that courts refer to all the time without it being an exhibit. Now, the DSM-IV was the one in effect at the time. In 2018, they came out with the DSM-V. It took out that malingering even as something to consider at all in PTSD cases, right? The current diagnostic tool for PTSD doesn't even include that malingering differential diagnosis. The bodily injury cases that the Supreme Court has decided, first of all, two of them do treat it as ambiguous, but they do not require the person to be injured. In particular, the Connecticut guarantee case, the Supreme Court decided a few years ago, it was about a wife's loss of consortium being covered under bodily injury because her husband had been physically injured by a physician who committed medical malpractice. The Supreme Court said, well, it's an ambiguous term. We construe in favor of coverage, and the policy term is ambiguous. Even though it's a derivative claim, even though the wife is not injured, it comes within the broad reading of a bodily injury. Finally, this is not a double recovery case.
Well, your time is up, Attorney Chris.
I'll rely on my brief for the cross appeal.
Okay. Thank you. Attorney Hart?
Procedurally, I think I'm only really allowed to reply to the Del Greco argument, which wasn't really reached, so I don't want to be out of bounds here, which doesn't leave me with much with my 11 minutes. Yeah.
So if there's anything else you want to say with respect to the cross appeal.
I'll just say this. Procedurally, I'll respond to the last. This is a double recovery situation because when you add in the DRAM recovery for the plaintiffs, all the plaintiffs remaining, they would recover more than the value of the case as determined by the trial judge, who, by the way, also awarded not just economic damages, but non-economic damages. In fact, it was greatly exceed what he found to be the fair value of their case. So it is a double recovery situation. I guess I leave it there.
Okay. All right. Thank you both. We really appreciate you participating in this virtual courtroom. We would much prefer to see both of you in the actual courtroom, as I'm sure you would like to be in the actual courtroom. We hope to get back there very soon. It's an interesting case. We'll take it under advisement, and we will stand adjourned until 9:30 tomorrow morning. Thank you both. Have a good day.
Thank you, Your Honors.